Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address the critical issues facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics from Social Security to finance to family law. And most recently, we've been discussing family law and, in particular, divorce. At the end of every segment, we ask you, the audience, to email in questions that you may have that are addressing some of the topics that we've covered. And once again, we have to respond to those questions our attorneys, Jackie Grasso and David Bazaar from Audette, Bazaar, Cordeiro Grasso law firm in East Providence.
Hello.
And what was the question?
The question this week was a general question about how long does it take to get a divorce if it's an uncontested divorce. The question was not specific to Rhode Island and Massachusetts, so I thought what we would do is answer it for both states. I'll take Rhode Island, you do Mass.
Sure.
In Rhode Island, the answer is you have a 60-day waiting period before you can get a hearing, and then after the hearing, there's a 90-day waiting period before the final judgment can enter. Generally, it's 150 to 160 days. You have to get the court date, which usually takes a little bit more than the 60 days. It's assigned when the case is filed. So I say 5 to 6 months is about the right answer.
Okay, and in Massachusetts, an uncontested divorce takes probably about, probably about 4 or 5 months, similar to Rhode Island. When you file your uncontested case, you get a hearing date within 30 days. From the date of the hearing, there is a 4-month waiting period, not 90 days. So it takes an additional 4 months. That's what they call the NISI period or the NISI period. And once that period has expired, then the court automatically sends you out your final judgment, or it's called a certificate of divorce absolute.
And at that point, does it mean if someone wanted to remarry, they could remarry right then, or do they need to wait another X months?
No, as soon as it's final, they can remarry. You cannot remarry in the NISI period because technically you're still married.
And in Rhode Island, the same thing. While the decision pending entry of final judgment is the only document, you're still married until the final judgment. And the only other caveat I should throw in is I gave you the answer for a divorce based on irreconcilable differences as opposed to living separate and apart, which would have a 30-day waiting period after the case is heard.
Living separately, for how long?
3 years.
3 years separately,
Yeah.
Then it expedites it or fast tracks it,
That's
so to
correct.
speak?
If the grounds that you use is living separate and apart for a space of more than 3 years, then the 90-day waiting period no longer applies. It's the appeal period, generally about 30 days.
Okay, so while we've talked about dividing up assets and what to do with children, in this segment what we're going to address are issues relative to children, adoption, guardianship, DCYF and the social services, and there are, I think, enough topics there that we could take 12 segments, but let's see if we can give a quick overview and address some of those critical ones, starting with, is it guardianship or adoption first?
Well, why don't we start with adoption? Adoption literally is a termination of parental rights. So the only entity that can terminate parental rights is the state, i.e. the court.
Right.
It would come at the request of, if it's a state requested adoption, it's coming through DCYF, Department of Children and Families, or Massachusetts Department of Social Services. It could be a voluntary adoption wherein the parent agrees to an adoption in the usual course. Doesn't mean anything bad has happened. The state is not forcing an adoption, but it's just an individual decides to give up a child at birth. Either way, it has to be approved by the court. You cannot have an adoption unless it's approved by the court. If it's an involuntary adoption, then it's based on some kind of negligence towards the child or children, or child abuse, something so egregious that the court has taken a position that they should no longer be parents. And
Right.
once you give up your parental rights, once they're terminated, they're gone.
And when you say an involuntary adoption, you mean an involuntary termination of parental rights?
Yes, it's an involuntary termination of parental rights, and the only entity that has standing to do that is the state.
With birth mother, birth father, do they have equal weight when the court system or the social services are taking a look at who's negligent or who's able to take care of the child? Do they have favor the mother if she's competent versus he is? Are they equally weighted, or how does that work?
You want to take that?
Well, I think as the question's posed, what you're really saying is if a mother is at fault, for instance, can the father still retain his parental rights or vice versa?
Yes.
And the answer to that is yes. Depending on the situation, what they won't do, though, is put a child back in the same house with the abusive parent. So unless the husband or the wife, if they're married, or the father or the mother agree that they're going to live separate and apart from the abusive parent, it's going to create an issue for both of them.
And also, too, if the father is not involved in the child's life, he is still entitled to due process. And it's the same thing. We say father. I don't want to be,
Right.
Sexist here. But if one parent is not involved in the child's life and the other parent is going through this process, if it's involuntary or voluntary, they have to put the other parent on notice. So they have a right to be heard. The other parent has a right to be heard. It's due process. It's called due process. And if the other parent doesn't agree, if it's a voluntary adoption, then you're going to end up going to hearing on that.
Yeah, and what happens? Private adoption, voluntary adoption, typical situation. Mom and dad get divorced. Dad, let's say, I'm not going to say this is typical, but let's say that parent is not involved in the child's life at all for years and years and years. The other parent, call it the mom in this case, remarries, and now the new husband wants to adopt the child because he's been raising that child for a while.
Anyway.
The prior father or mother,
Birth father
or mother, can sign a petition, a voluntary adoption petition, and that's what Jackie's referring to as a voluntary adoption. What happens even in that case is DCYF needs to investigate the home where the child will be living to make sure it's appropriate for the adoption. And then the court has to get that report and see the people and meet with the people and agree to the adoption and approve the adoption.
Yes, and in all cases, the state has a duty to investigate the home of the adoptive parents.
What happens in the case of guardianship? It's not an adoption, but they're the person who has legal charge. How does that work, and how is that any different? Is that an interim state before adoption?
I think the difference, one would conclude the difference between a guardianship and adoption is in one, you're not giving up parental rights. For instance, let's say parents have to be out of the country because we're in the middle of, unfortunately, a war in Iraq and Afghanistan. They have to be out of the country. They're on a 2-year tour duty. Somebody needs to have a say in the child's or children's lives. So the best way of achieving that is you petition the court for guardianship so that when the parents are out of the country or they're absent, whatever reason it is, the guardian, the legal guardian, who has to be approved by the court, then has the authority to act on behalf of the child. And again, the standard is always what's in the best interest of the child.
The guardian stepping into the parent's shoes when the parent can't fulfill his or her responsibilities. The big question there, or the interesting question, is where's jurisdiction, family court or probate court in Rhode Island? And there's some case law on that. You want to address that?
I think probate court has learned from case law several years ago is that if there's an issue that's going to be contested, and it involves children, family court should have the ultimate jurisdiction on guardianships.
Right.
They can hear guardianships of a minor, but I think they'd much prefer, if there's going to be a contested issue, it needs to go to the family court.
The probate court and the family court have what we call concurrent jurisdiction, which means they both have jurisdiction over guardianships. If it's an uncontested, agreed-upon situation, mom and dad or one or the other is away or can't fulfill their obligations, and they sign the petition. If the child's over 14, the child will sign the petition. Then probate court's perfectly fine place to have the guardianship heard. If it's a situation where, in a case that I remember going back a little ways, husband and wife are divorced. The child lived with the mom. The father had very little of any contact, never paid child support. And in the mom's will, she said, I want my parents to have guardianship over the child if something happens to me. And she did